I love the challenge of summarising judgments for these case notes, but sometimes any summary is going to be inadequate. This is one of those occasions. These were actually two matters heard together. In the first case, Ebner, the judge, was a beneficiary of a trust which had held 8,000 ANZ Bank shares. He gave judgment in a bankruptcy matter where the ANZ Bank was one of the creditors. In the second case, Clenay against the ANZ, the judge was not a shareholder at the time of the trial, but between trial and judgment, his mother died, and she left him 2,400 ANZ shares in the bank. Now, for perspective, at the time, the bank's capital was roughly 1.5 million shares, so the judge's shareholdings were insignificant. And the sums involved in each case were insignificant to the bank. Winning or losing the case would have no impact on the bank's share price, and therefore no impact on the value of the judge's shareholdings. In both cases, the losing party objected that the judge had a conflict of interest. A fundamental rule of procedural fairness is that a decision must be made by an unbiased decision maker. There are two types of bias: actual bias, where the judge is acting in a biased way, and apprehended bias, where the judge might well be doing everything exactly right, but there's still a reasonable apprehension that they might be biased. The majority judges in this case describe the principle in this way. Where a question arises as to the independence or impartiality of a judge, the governing principle is that the judge is disqualified if a fair-minded lay observer might reasonably apprehend that the judge might not bring an impartial mind to the resolution of the question that the judge is required to decide. That principle gives effect to the requirement that justice should both be done and be seen to be done, a requirement which reflects the fundamental importance of the principle that the tribunal be independent and impartial. They then undertook a deep and detailed historical analysis of the apprehended bias rule. I just can't summarise that here. You will learn heaps if you go and read it for yourself. They concluded that since neither of these cases could possibly have affected the share price, neither judge had anything to gain or to lose from their judgment, and so they were not excluded due to apprehended bias.